What happens if you're convicted in a criminal case in Massachusetts? What steps can you take to try to overturn that conviction? Well, you have a right to appeal. Now, in every type of case except for a first-degree murder, that's a separate type of appeal that goes right to the Supreme Judicial Court. Every other case goes to the appeals court. The process is fairly straightforward, but there are a lot of steps, and you have to make sure that you complete all the steps, or else you risk having your appeal be dismissed. So the first step, the very first thing you want to do is to make sure that a notice of appeal is filed in the trial court, whether that's district or superior. It goes to the court where you had trial. And so usually a one-page piece of paper. It says the defendant, John Smith, gives his notice of intent to appeal certain rulings. You know, there's certain language you put in there. It's usually about a paragraph. It gets submitted to the clerk, a copy to the prosecutor, and that gets your foot in the door. That's the first step. After that, within 14 days, you have to request the audio from the trial and from whatever other hearings you want to have the appeals court review. So you get the audio, then you send it to a transcriptionist, a court reporter, and that person puts the audio onto paper. You also have to notify the clerk's office at the trial court and the other parties as to which dates you had requested transcripts for, and send in those transcript requests. Once the transcripts are completed, which can take anywhere from a few weeks to a few months generally, the transcriptionist is supposed to give the transcripts to the trial court clerk. Now, I always make sure that that's done, so very often I will double check with the trial court clerk once I know that the transcripts are completed to make sure that the trial court clerk actually has them, because if the transcriptionist doesn't give them to the trial court clerk, I will do that. I will make sure that the transcripts get to the trial court clerk. Now, the clerk's office will notify the parties that the record has been assembled. Basically, that just means that the paperwork from the file has been put together and is being submitted to the appeals court. Within 14 days of the notice of assembly of record, the appellant, the person who's doing the appeal, has to notify the other side about which documents within the case they want to make sure are included in the appendix. Usually that includes the docket, motions, court decisions, things like that. And then the other side, the prosecutor has 14 days from then to designate additional parts of the record, things that they want to make sure are included. Now, most of the time, the parties can agree on what gets included. Soon after the trial court notifies the parties that the record has been assembled, the appeals court will notify the parties that the case has been entered into the appeals court. 14 days from that entry date, the appellant has to file a docketing statement. It's a form that notifies the court as to what the type of case is, who was the lower court judge that heard the case. There are a few just kind of general pieces of information that you get to fill out, submit it to the court, send a copy to the other side. Also, within 40 days of the case being entered into the appeals court, the appellant, again, the person who's doing the appeal, has to file their brief and their appendix. Now, very often, because cases are complex and takes longer than 40 days, the appellant can request additional time. That's not always done, but it's pretty typical for that to be requested, and the appeals court almost always grants at least the first request. So at some point, whether it's within 40 days or within additional time permitted by the appeals court, the appellant will file the brief, which is basically the legal argument as to why the case should be overturned, why the conviction should be overturned, files it with the court, copy goes to the other side, same with the appendix. From then, the appellee, usually the prosecutor, will have 30 days to file a response. After the appellant files and serves the brief, the appellee, the prosecutor, has 30 days to respond with their own brief, and they can argue why the conviction should stand. So they write their legal brief, they submit it to the court. Again, if they need more time, they can ask, and very often the prosecutor asks for more time and they're granted more time. But they ultimately submit the brief, and if they want to submit a record appendix, if the parties hadn't agreed on the context of the appendix, the prosecutor can file their own appendix and include additional documents that they want the appeals court to see. Once that's submitted, if the defendant wants to include a reply brief, they can. It's usually not done, but once in a while it makes sense, and they have 14 days to file a reply brief, basically a reply to the prosecutor's brief. Once all that's submitted, it's all in the appeals court's hands, and they will do one of two things. They will either schedule the case for oral argument, in which the lawyers can come in and each make a 15-minute argument as to their position, and then a decision is made, Or in some cases, the appeals court doesn't have an oral argument, and instead they just issue a written decision based on the parties' filings. And typically there's about 3 different ways this can shake out. The appeals court can and usually does affirm the conviction, basically saying we're not going to disturb the jury's findings, everything was done the right way, we're not going to change anything. They can say, yeah, there was some legal errors, we're going to change a guilty verdict into a not guilty verdict, and that's the end of the case. Or a third option is the appeals court can say, yeah, you've raised a good issue, we're going to remand. Basically, we're going to send the case back down to the trial court with some instructions for the trial court to take further action and finalize the case there.